Well, good morning, everyone, and thank you for being here. I'm Elizabeth. I'm the communications coordinator with the League of Women Voters of Ohio, and we are here today because reproductive health is on the ballot this year in Ohio, as Issue 1 asks voters to approve an amendment to the Ohio Constitution that would codify abortion and other reproductive health care. And we want to help voters understand what's involved so they can make a decision that is informed by their values and the facts and not by political spin or misinformation. Very few of us here are healthcare providers or medical experts or legal experts. So we wanted to provide an opportunity for you all to hear from folks who have the expertise to transcend the noise that is surrounding this issue generally, and just to specifically talk about Issue 1. We're going to start with just a little bit of backstory to give us some context for how we got here, and then go into more about what Issue 1 is about, what it would mean for Ohioans, and then discuss questions that we've heard from voters in the weeks and months leading up to this election. But first, we are very proud to introduce our experts this morning. Dr. Maria Gallo is a sexual and reproductive health epidemiologist, professor of epidemiology, and associate dean of research at the Ohio State University College of Public Health. Welcome, Maria. And Jonathan Entin is a professor of constitutional law, civil rights, and public policy, and is the David L. Brennan Professor Emeritus of Law at Case Western University's School of Law. Welcome to you both, and thank you for letting us have a little bit of your time on a Saturday morning. Our moderator today is well known by many of you. Jen Miller is the executive director of the League of Women Voters. We want to start with how we got here, which itself could be the subject of many a webinar, and we don't want to spend too much time here. And of course, this timeline is just a snapshot of decades-long back and forth about reproductive health care in Ohio, but we thought that it would be helpful and important to provide a little context for why we're going to be voting on Issue 1 this fall. In 2019, after many years of trying, Ohio passes SB 23, which was a law banning abortion after 6 weeks of pregnancy. The law includes possible jail time for doctors who violate the law and does not include exceptions for rape, incest, or the life of the patient. It was first introduced as a bill in the legislature in 2011, and then years of back and forth before in 2019, Governor DeWine signed it into law. But before the law could go into effect, a federal court blocked it, putting it on hold to let it go through the courts. And so this meant that abortion access in Ohio continued as it had been, but the law did not go away. It was just paused. And then in June of last year, the Supreme Court of the United States ruled in favor of Mississippi's laws restricting abortion in the Dobbs case, which overturned Roe versus Wade, making abortion, which itself had made abortion a constitutional right in 1973. And so this ruling left abortion legislation up to the states. A few hours later in Ohio, the Ohio Attorney General filed a motion to dissolve the injunction against the 2019 6-week ban, which was granted because the ban was no longer unconstitutional. So at that point in June of 22, abortion after 6 weeks was banned in Ohio. A few months later, and actually, you know what? A few months later, a reproductive rights coalition filed suit against the state to challenge the 6-week ban. There was a judge in Hamilton County Court of Common Pleas who temporarily blocked the ban and then extended the injunction conditionally, which meant that it restored the right to abortion in Ohio for a while as the case again made its way through the courts. And that's where we are right now. But actually just this week, the Ohio Supreme Court heard arguments in the case brought by the state of Ohio, appealing that preliminary injunction granted by that Hamilton County court judge. and the Ohio Supreme Court could rule at any time. So meanwhile, and Mooney, if you want to change the slide, after the Dobbs ruling, a coalition of reproductive rights organizations formed to put a constitutional amendment in front of Ohio voters that was intended to restore abortion rights and protect reproductive rights broadly. It received enough signatures over the summer to get that initiative onto the ballot for this fall, and that's what we'll be voting on starting on October 11th. This incentivized the Ohio legislature to hold a special election on another constitutional amendment, and some of you are very familiar with this one after having gotten through the last special election. And that constitutional amendment would have required that citizen-initiated constitutional amendments get 60% of the vote to pass, which would have been a change from the 50 plus 1% that has been the standard for over 100 years in Ohio. This vote was scheduled to happen during an August special election, the timing of which was speculated to be for the purposes of thwarting the proposed reproductive health amendment that we are talking about today, issue 1. And I mention this because though there were a great many of other things at stake during the August election, it got a lot of national attention because some people considered it to be a proxy fight for abortion. And this is where we started to see some real patterns of disinformation, which has only gotten louder since then. And with that, I'd like to turn things over to the people you're here to see today. So, Jen.
Thank you so much. And I think we can turn down those slides. I want to welcome Jonathan Entin. How would you, and I actually didn't ask either of my guests how they would like to be referred. So, Jonathan, how would you?
Doesn't matter.
Doesn't matter. And Dr. Gallo? Maria, I think you're on mute, but I think I was able to read your lips that one time. You said Maria. Yes. Okay. Thank you so much. All right. We're going to jump into this. Thank you for everyone who's joining. Go ahead and put your Q&A in the chat, knowing that you might get your answer soon on, but we're actually going to wait until we get through this program to really jump into questions and answers. But we do have a few folks behind the scenes that could answer some questions. Elizabeth, if there is a clarifying question that you think is really important to jump in, please just interrupt me, okay? So we are going to start with what issue 1 would do. So the language is establish a state constitutional right to make and carry out one's own reproductive decisions, including abortion, contraception, fertility treatment, miscarriage care, and continuing pregnancy. And there are, of course, some prohibitions of the state that we will get to, but in functional terms, let's focus first on abortion access. And this is a question for both of you. I think most of us are pretty familiar with how access worked under Roe v. Wade until the Dobbs decision. And so let's use that as a baseline, not in a legal sense, but in a practical sense as a patient. What might be the same or what might be different if issue 1 passed? So what, as a patient, if I'm walking into a medical facility and issue 1 passes, what would be similar to the way access worked under Roe and what might be different?
Well, I think access would likely be quite similar because issue 1 embodies a very strong reproductive right, and it imposes a pretty substantial burden of justification on the state if it wants to limit that right. Now, the state may be able to impose some kinds of regulations that apply to health facilities in general, but I think it would be more difficult for the state to impose regulations that are specifically addressed to abortion providers because the state would have to justify that under the essentially the health-based evidence justification, and a lot of the sorts of regulations that states were trying to impose before Dobbs failed that standard.
Yeah, Maria, please.
Are you able to hear me?
Yeah.
Okay, great, wonderful. Yes, I agree with Jonathan. I think one of the things that this will do is that if it passes, these targeted regulation of abortion provider laws, these laws that are designed to make it more difficult to access abortion, I think they might be not enforceable, or it would have to go through the court system to see if they're enforceable, right? Because it would interfere with this part of the amendment that says that you'd have to use the least restrictive means to advance an individual's health. And so we have lots of targeted regulation of abortion provider laws in Ohio and elsewhere in other states. This is something that is used to try to make it more difficult to access abortion. And that's something that I think would be harder to use if this amendment were passed.
Great. So let's talk about those prohibitions, because you both kind of got in there. It would prohibit the state of Ohio from interfering with this constitutional right, except when the state demonstrates that it is using the least restrictive means to advance the individual's health. And also would allow the state to restrict abortion after fetal viability, unless it is necessary to protect the pregnant patient's life or health. So do you want to kind of talk about that? And again, let's talk about this as, I know this stuff is wonky, but in kind of basic terms, what that means, Maria.
In basic terms, what the amendment means is that there would be embedded in the Constitution a right to make your own decisions about reproduction, about reproductive health care for abortion, but then the amendment lists other things that are not included, I don't think, in the ballot. It would also create legal protections for people who are helping with the abortion so that they don't have to fear prosecution. The state people wouldn't have wouldn't have the right to abortion after viability, unless in the case that it was needed to protect the person's health or wellness, right? I think that if we can get a little bit big picture for a second, I think the other thing, maybe important thing, and we're kind of in the weeds right here, but we want to step back for a second. I think one thing that the amendment would do might be to help clarify for people that abortion is legal, right? If we have it in our Constitution, we're removing some of this doubt right now that we have. It's confusing. We started out with that, lovely slide that told us the history of the 6-week ban. And that was really broad strokes, right? There was a lot going on. It's introduced, it's passed, it's vetoed. We have a new governor come in, they allow it. All this results in a state of uncertainty for a lot of people about what they're allowed to do, right? Can they get an abortion? Are they allowed to access it? We did a population representative survey of adult reproductive age women in Ohio before Dobbs, while Roe was still in effect. So in 2018-19, we surveyed a representative sample of people in Ohio, and people were confused, right? 10% of people thought at that time that abortion was illegal. This was before the fall of Roe. People already thought it was illegal in the state. 26% of people said, I don't know if it's legal or illegal. So you had well over a third of people say they don't know whether abortion is legal or illegal because of all these laws that are introduced, all these restrictions. This is confusing. I work in this space and I'm confused. I mean, maybe Jonathan understands all the laws, but I don't. It's hard to keep track of it, right? And so it sort of introduces a state of confusion about what the person's allowed to do and what the provider is allowed to do. And I think an important thing for this amendment, by putting it into the Ohio Constitution, it kind of makes clear to people, you have the ability to get an abortion. You have an ability to get contraception. These are things that are part of your right to access as part of your healthcare. And to me, we can get into the details of, the trap laws that might no longer be legal or illegal, may be allowed or not allowed. But to me, this is sort of a big picture thing that this amendment would help make clear to people what the state of the law is.
And let's jump into some of the other aspects of reproductive decisions. So contraception, fertility treatment, miscarriage care, and continuing pregnancy. Can we talk about, aren't those aren't there already protections for those things? Why is that need? And I think you got there, but let's talk a little bit more about why that might be part of this amendment.
Well, one thing we can say is that the federal Constitution protects access to contraception at this point. But we ought to note that in the Dobbs case, Justice Thomas wrote a separate opinion saying that he would overrule the cases that protect access to contraception. And at least one member of the General Assembly has introduced a bill that would outlaw at least some forms of contraception. So one reason why the proponents might have included the right to contraception is to cover the eventuality that maybe at some point the federal constitutional right to contraception might be undercut or even overruled. But the other reason to focus on these other aspects of issue one is that this is a package. The proponents are talking about this as a right to reproductive freedom, and that embodies a whole series of things besides abortion, and that's why the amendment includes these other items, because they're all kind of related to each other.
Thank you for that. So there's so much confusion, and some of this actually goes to the fact, and Jeanette Schultz has a very good question that I think is so important. Is that what I see on my ballot when I go vote in November actually the language that lands in the Constitution? Why or why not?
No. And that would be true even if there hadn't been controversy about the ballot language to begin with. It is very clear under Ohio law that when we vote on a constitutional amendment, we are voting on the language that was in the proposal. But what's in a proposal is—
and let me just interrupt. When you say proposal, you mean the thing that voters signed.
Right.
The full text.
Right. The full text of the proposed amendment is what we're voting on, up or down. Now, in this case, the full text is only 250 words, and so they could have put all of the language on the ballot, and people could have read it right there. But the law doesn't require that, and many proposed constitutional amendments are much more complicated and wouldn't fit on the ballot. So what we get on the ballot instead typically is some kind of summary that is supposed to be a fair and accurate summary of what's in the amendment. As I said, there's been some controversy about whether this is a fair and accurate summary, but the Ohio Supreme Court has said that it is. For what it's worth, the full text of this proposed amendment will be posted at every polling place on the wall. So you can, when you go to vote, if you will have the opportunity to read the entire language, even if even though it's not, the full language is not on the ballot.
Thank you. All right, let's keep going. So this is one of the reasons why we are so committed to voter education, because we want to make sure that every voter, when they step into the ballot box and think about something as this important and this fundamental here in Ohio, that's based on what the amendment would really do, and really so that way they can actually vote their conscience rather than vote out of fear or confusion. Let's keep going. We got some more questions, unless you had something else you wanted to say, Maria.
No, let's go on.
I somehow have lost all my questions. I'm not sure how or why, but that's okay. Let's talk about viability. We've had a lot of questions about viability. So what, and can you talk about why viability matters and who defines viability and about when that is. And I'll start with you, Maria, please.
Sure. So when we talk about viability, we use this term, but it really comes into play two different times, right? So, and we can think of it as two different ways. At the beginning of a pregnancy, we say the pregnancy is viable, meaning early during the pregnancy, there might be things that have happened that the pregnancy just won't continue. It's not possible to continue this pregnancy. So if you have an ectopic pregnancy, that's not going to continue. That's not viable. There is no magic thing where you can move the ectopic pregnancy inside your uterus and continue. It's not a viable pregnancy. So that is, these things are relatively more clear cut. The pregnancy won't continue. It could be dangerous to continue. If you have an ectopic pregnancy, you may very well need to have life-saving treatment for it. And so that's that's one way that we use viability. The other way to think about viability is later, and this is what often we're thinking about here, is the pregnancy able to continue? If it were outside of the uterus now, right? And that is something. So can the fetus survive if it were outside of the uterus? That's a way of thinking about viability later in the pregnancy. There's no test for this. There isn't an exam that you can do. It's not a definitive diagnosis. There's not a diagnosis that says this pregnancy is viable. And so this is something where the clinician needs to make a judgment about it, and you're dealing in probabilities. What's the probability? Before 23 weeks, you have very little chance of viability. And even if it were to survive outside, you're dealing with lots of morbidity, substantial. You would likely have substantial amounts of more serious morbidity. Later, as the pregnancy progresses, viability, the chances increase, although it relates to other things other than just gestational age. So it's not just based purely on gestational age. You also have to consider the infant's weight, whether it's a singleton infant, whether it's multiples, the type of care that the person has received during their pregnancy, and then after, when they deliver, will they have access to a NICU unit? Will they have access to intensive care? So it's not an either or thing. And so the amendment puts in the language of, this is the provider's, the physician's determination as to whether the pregnancy is viable, because we don't have a test for it. That's at the heart of it.
Thank you. Did you want to jump in here at all, Jonathan, or you want me to keep going?
No, I think Maria's done a really good job explaining something that is really not a legal term. I mean, when lawyers and courts talk about viability, they're really talking about it in terms of the medical concept as sometimes qualitative or imprecise as it might be.
Thank you for that. And I think this is why we are suggesting local leagues to have events where you bring a medical professional and a legal professional in, because I'm not a medical professional, right? I don't know what viability means. And there is a piece in here about case by case basis. Can you explain that, like maybe give us the language on the case by case basis and what that's referring to?
Well, there is a provision in the amendment that says that in no case with a post-fetal viability abortion may the abortion be prohibited if, in the professional judgment of the patient's treating physician, it is necessary to protect the pregnant patient's life or health. Now, this is analogous to the framework that we had in Roe against Wade, although it's different in a sense. Roe against Wade talked in terms of trimesters and said that there would be different rules in each trimester, but even in the third trimester, the court said the state could prohibit, but still needed to make an exception for the patient's life or health. This amendment really does not work with trimesters. It uses viability as the line, and so in that sense, maybe the timeline is a little more straightforward, or there are fewer places on that line. But I don't see this language as really legally all that different from the third trimester rules in Roe.
Maria, you want to jump in?
I'll just say that's because this amendment was written in part with the input of doctors, and trimesters have no scientific basis. There's no basis for a trimester. So it makes sense, we've sort of evolved in our thinking and included doctors, providers have had input into this. And so it doesn't make sense to think about trimesters. It has no medical basis and is sort of a crude way of looking at pregnancy.
So so can we just talk in practical terms, Maria? Someone goes into a doctor, a pregnant person goes into a doctor, they are thinking about getting an abortion. What are the kinds of things a doctor is going to look at to determine whether the fetus is viable, that we have hit the point of viability or past it?
Sure. So I'll say I'm not a medical doctor. I'm full disclosure. Don't come to me for medical care. I'm an epidemiologist. I do, I study sexual and reproductive health, but I'm not providing any medical care, and so this should not be taken as a medical care in any way. But if they come in, a primary determinant of viability is gestational age, how far along you are in the pregnancy, right? And so, like I said, if you're before 23 weeks, you don't have much, it's not very, your likelihood, your probability is low. If you're at 24 weeks, viability, you're maybe at 42 to 59%. Greater than 25 weeks, it increases. So you're up to 67, 76%. So your probability of viability increases as time goes on. But there are other factors that the doctor is going to look at. So your physician's going to look at, they're going to do an ultrasound. They're going to see the size of the baby. What's the baby's weight? How are they developing? That gives you that will weigh in on that the weight will weigh in on how viable it is. They'll look at the types of care. Have you been receiving prenatal care? Have you been, do you have growth? Is the infant appears to be growing? So they're going to look at these factors, and also depending on where you are. If you're in a place that doesn't have a NICU unit, the chances of viability are not going to, if you're delivering in some place that doesn't have that advanced specialized care, your chance of viability is lower. So they're going to consider all these things together. The thing that I would say is that I think we've seen is that the law isn't really adequate for thinking about all the possibilities that somebody might encounter. We can't really create a law to determine viability. You really need to rely on the physician, on the doctor's expertise here, and considering the person as a whole, right? People are complex, medical situations are complex, people don't fit into like neat little boxes. And so the law is really a blunt way, it'd be a very blunt instrument to try to do this. We generally, when you try to use law to legislate, to make laws about medical care, you're going to run into problems because there will be these edge cases. These things don't fit into those boxes.
And I think, Jen, to come back to the earlier point, this amendment, if it were adopted, would effectively prohibit a bright line rule that says after X number of weeks, we've defined the fetus as viable. That's where the amendment says we're going to make this call on a case-by-case basis. So some people who are at X number of weeks, the physician will conclude that that we're talking about a viable fetus, and in another situation with the same number of weeks, of the same physician even might conclude this is not viable.
Thank you for that. How common are pregnancies terminated in the third trimester, Maria? And if someone did terminate, what would, if this were to pass, what would be allowable? Can you just give some perspective there.
Yeah, so not many pregnancies are terminated or have an abortion later in pregnancy, right? Overall, probably less than 1% are later in pregnancy. If we look at Ohio, our Ohio Department of Health brings together, they monitor the abortions that happen in our state. And our most recent report that I have is from 2021. And we can see here that 87.5%, so 88% of abortions occurred within 12 weeks. So early. People generally are having abortions. If they're able to access it, they're having it early. So 88% occurred less than 12 weeks. Only in that year in Ohio, only 0.7%, so less than 1% occurred after 21 weeks. The state doesn't release at what week those, that 0.7%, that less than 1% occurred, but by far the majority, almost all abortions are happening earlier in pregnancy. These later abortions are really because of tragic circumstances.
Thank you so much for that. All right, let's get into some other areas of misinformation that we've heard. So one has to do with parental consent. I've heard a lot of scary language about parental consent. So, Jonathan, what laws are on the books regarding parental consent, regarding minors seeking healthcare and especially abortion?
Okay. Right now, Ohio has a law that says that in order for a pregnant minor to obtain an abortion, she must get the consent of one parent, or she can go to court and get a ruling after a hearing that the abortion is in her best interests. That's been the law in Ohio for a long time. Now, I don't think that this amendment, if it were adopted, would change that. And I say that for two reasons. One is there's nothing in here about parental consent one way or the other. I know that some opponents have been saying, well, because this amendment talks about individuals, that somehow that means that minors have exactly the same legal rights as adults. But I don't think that that is consistent with the way we normally interpret language like individual or person in the federal Constitution. But beyond that, I think that we have some evidence about the legal status of parental consent laws before Dobbs. The U.S. Supreme Court, in a number of cases, under Roe and under Casey, upheld laws that are very similar to the current Ohio parental consent law. That is, one parent consent or this kind of judicial bypass process.
Thank you. How common do you think it is to use the judicial bypass process? I would imagine that is very rare for a young person to use that. Maria, do you have any stats on that?
I don't have them off the top of my fingertips. I don't remember the stats, but yes, it's rare. I mean, you're talking, it's tough to do that, right? Most minors are not equipped to go through that system. If you imagine how difficult you would find it, I mean, it'd be much more difficult if you were a minor. So most are not going to make it through that. It's not something that is widely used. And I agree with Jonathan. I don't think that this amendment it does not seem plausible that this amendment would be interpreted as extending these rights to minors. But for transparency about this conversation, I mean, I will say that I think that people who are pro-abortion would say that we should be extending this to minors, right? And so while it's not in this amendment, I do think that this is something that people would be arguing in the future that we should be doing.
Got it. So if this passes, it doesn't appear to change parental consent regarding minors seeking abortion. That might be something that someone works on down the line.
It seems conceivable that we would encounter this issue in the future.
Got it. Thank you.
But I would also say based on what the U.S. Supreme Court has done in the past in this area, that I think it would be unlikely that the Ohio courts would construe this amendment, if it were adopted, as exempting pregnant minors from the parental consent rules. Now, presumably, if the General Assembly decided that that was a good thing to do, it could pass legislation, and I don't see anything that would preclude the General Assembly from doing something like that. But given what the General Assembly has been doing in this area for a while now, I would say that that's not a realistic prospect.
Thank you. Let's go into another area of mis and disinformation. Has to do with gender-affirming care. And so first, actually, I think it would be good to give some sort of definition of gender-affirming care. And then secondly, Maria, if issue 1 passes, would minors be able to access gender-affirming care without parental consent?
So gender-affirming care is very broad, right? It's a broad concept. It's this idea that we give supportive health care that that is consistent with somebody's gender, right? And so that could span just using somebody's pronouns, using it to acknowledge that you acknowledge their identity that they're presenting. When people are raising the issue of gender-affirming care here, they don't mean the full span of gender-affirming care. They're really focused on gender-affirming surgeries, right? So let's be precise about what we're talking about here. This is the concern that people would be having, that minors would be allowed to have surgery to change their gender. And so there's nothing in this amendment. This amendment deals with reproduction. Gender-affirming care is not reproduction. I don't see, I mean, Jonathan can answer this, but when I read the amendment, to me, it specifically mentions several areas: abortion, contraception, the right to continuing your pregnancy. These are all, it's designed around reproductive freedom. It's not designed around gender-affirming surgery. I don't read this into it at all.
No, and I agree with that. In fact, I would take this further. I don't think it is plausible to read the language of this amendment as protecting right to gender-affirming care for anybody. I mean, adults or minors. And I would say this just applying traditional legal rules for interpreting documents. This is this amendment contains a list of reproductive related rights that it protects. It also says including but not limited to, and that's where the claims about gender-affirming care come in. But the standard legal rules that have been around for decades, centuries even, say if you have a list in a document that says including but not limited to, then in order to add something to the list, the item has to be plausibly related to the items that are already there. Now, yes, it is true, I suppose, that if somebody has gender reassignment surgery or some other kind of gender-affirming care, that might have some implications on the person's ability to reproduce. But that is such a long stretch from contraception, fertility treatment, continuing one's own pregnancy, miscarriage care, and abortion, that I think that courts would just not go there because it's such a long stretch. We could talk about other sorts of things that have potential implications for somebody's ability to reproduce that I don't think would be implicated in this amendment, even with the including but not limited to language. So I think this is a stretch number just on standard legal interpretation. But beyond that, it seems to me that if that argument, if the argument is that somehow this covers gender-affirming care, it's not, as I said at the beginning, it's not just for minors, it's for anybody. And I just don't see that as a plausible reading of this amendment. I mean, I can think of any number of reasons why somebody might vote against issue 1, but this isn't one of them.
Okay, so let's do some quick, and you both gave really good information here, but let's do some just quick true or false. True or false, if issue 1 passes, it would change parental consent for minors seeking abortion.
False.
True or false, if issue 1 passed, it would allow gender reassignment surgeries.
I think that's false also.
Okay. True or false, it would allow women, just if they just don't feel like having a baby, or a pregnant person, true or false, if issue 1 passes, it would allow a pregnant person to have an abortion just because they don't feel like having a baby late in the 3rd trimester.
That I think is also false, given the way this amendment is written. This amendment would allow the state to prohibit post-viability abortions, but would require that the state do so on the basis of evidence, and would require that there be an exception to protect the life or health of the pregnant person. And so I don't think that somebody who just decides willy-nilly after 7 months or so, oh, I don't feel like doing this. I'm not sure that if the state had a rule that said you can't have a post-viability abortion unless it's necessary to protect life or health of the mother, I think it would be really hard to fit this scenario into that sort of language. But let's be clear. Unless the state actually adopted a law that limited post-viability abortion, then presumably there would, people could get late-term abortions for any reason or essentially no reason. But I think we should be realistic and recognize that if this amendment passes, that the General Assembly is in fact going to try to regulate post-viability abortions in some way, and precisely what the General Assembly does might be the subject of litigation.
Thank you. Maria?
Clarify there. So I mean, a person couldn't go in and just say, I want to have a late abortion, an abortion late in pregnancy. They have to find a provider who agrees that their health or life is at risk if it's post-viability. And I think it is unreasonable to think that a provider is going to just say, in the absence of a reason, just say that this person has a reason when in fact they don't. Doctors have a duty to follow the evidence. They follow science. They follow regulations in their place of employment. They have ethical obligations. It just doesn't seem like a good faith argument to me to say that doctors will then be performing abortions after viability just on the whim of a person, right?
Thank you. That's what I wanted to clarify. Okay, so let's talk about miscarriages, Maria. And I have heard several horror stories from some of our members pre-Roe v. Wade who wanted to have children, who wanted to have the baby, but they were miscarrying, and some got very good treatment and some did not from doctors because of the legal fear they had. So can you talk about when someone is miscarrying, if issue 1 does not pass, what that could mean in terms of their care versus if it does pass?
Yeah. So miscarriage or spontaneous abortion, right? So just when you have a pregnancy and it spontaneously you lose your pregnancy, you miscarry it. That's super common. Happens often before people even know that they're pregnant. Lots of pregnancies do not last. You don't even know that you're pregnant and you have a miscarriage. So we're talking about something that is very, very common. And when the 6-week ban was in effect, we saw cases already where there were these tragic cases that occurred. We saw in September 22, when the 6-week ban was in effect, somebody made it into the national news. They were all over the news because they had traveled to Ohio. They were in the midst of a miscarriage. They were waiting for it to resolve. They traveled to attend a wedding, and they almost bled to death because the hospital wouldn't give them would not treat them for their miscarriage, because they needed, the hospital felt uncomfortable because they didn't know that there wasn't fetal development, and they needed, they didn't feel comfortable saying that it wasn't viable because they didn't know. And so I think, looking at that case, there are other cases. People show up, with an ectopic pregnancy, and the ER doctor doesn't feel comfortable saying that, in fact, it's not in the uterus, and that there was a case where then they had their fallopian tube ruptured. And so these are lifelong consequences to people. It can be serious. You can die. Your miscarriage might progress fine without any medical care, or you might need medical care and be at risk of death without it. And so care for spontaneous abortion is important, and people need to have access to this. The place where it gets a little bit tricky is that when doctors are operating, in those cases, in that case of that woman who almost bled to death, the doctor should have obviously treated her, but they didn't because they were worried. Why were they worried? Because they were facing, if somebody determined that that in fact was an abortion, they were performing induced abortion and not care for a spontaneous abortion, they were at risk of felony charges, 5th-degree felony charges. They were at risk of prison time, right? They could have gone to prison. They could have lost their medical license. They could have had stiff, heavy fines. I think it's easy to look at that circumstance and say, well, you will give the care that people need, but putting yourself, if we all put ourselves into a doctor's shoes and thought, think about all the time they went to school to get that medical license, they could be losing their livelihood. It's not unreasonable to me to think that they're going to err on the side of not providing that care. And that's a part where it gets dangerous. It gets, that's the part where it gets where it hurts patient care, and it hurts doctors. Doctors want to be able, they came into this profession because they want to be able to provide ethical, good care to people. And so this is the concern. When you start imposing these, like prosecuting doctors for providing care, when you start questioning, when doctors start acting with an eye to not how best to help this person in front of them provide care to them, but instead being concerned that they might have to answer in a court about what they did, I think this hurts medical care and it hurts doctors. So to me, this is one of the concerns with the 6-week ban, is that it will hurt people's care. We will continue to have these stories, these horrifying stories play out, which we saw in Ohio, we saw in other states that had 6 weeks bans.
So another one would be this is different, but if we think about rape and incest, right? So what happens right now? So yes, the 6-week ban came into place, and Elizabeth discussed this, but right now it's being protected. Access to abortion, miscarriage care, those things are being protected by a legal stay, right? And so if issue 1 doesn't pass, we understand what that could mean in terms of miscarriage care. What does it mean in the case of rape or incest, like the young girl who left the state to get an abortion?
Well, under current law, she left the state because she couldn't get care here legally. And I mean, part of the debate that we've heard about the so-called heartbeat law has to do with definitions. Some people who support the heartbeat law will say, well, some of the things that Maria is talking about really aren't abortions somehow. They don't think of those things as abortions, although doctors may well think of those in terms of abortion, or, as Maria says, they also may be concerned that however they think about the treatment that they're going to provide, they're concerned that other people might regard those as abortions, and some of those folks might then report them to the local prosecutor, or the prosecutor finds out, and so then you have this long this long chain of concerns. And meanwhile, if you're in a hospital, for example, the hospital has lawyers who are likely to say, well, here are the potential risks, and that just giving that assessment may kind of tilt the doctor's judgment in the direction of, well, I don't want to go to jail, I don't want to lose my license, all of those things.
Or the employer, and maybe the
Right.
doctor wants to do it, but the employer is
Right. And
risk-averse.
so right. And so part of the challenge here is that we don't necessarily have a commonly accepted definition of what we're talking about, and that tends to lead people to be risk averse, even when, as a matter of, and I'll defer to Maria on this because she's got the expertise I don't, but presumably the physician is concerned with treating the patient and not doing harm to the patient. But it's hard when you're looking at the possibility of really significant legal consequences if you do something that some third party comes in and says, well, you got it wrong.
Okay, so someone is asking that we get to the parental rights question, which we've already done multiple ways. So I think if we're just going to reiterate, Maria, quickly, because we need to wrap up, how this affects parental rights in any way.
The amendment is silent as to parental rights. It does not. It does not address this, but there's no reason to think that it's taking away from the current situation in Ohio, which is that minors cannot generally get care without, they cannot get abortion care without at least one of their parents signing off on it, unless they go through this complicated judicial bypass. There's no reason to think that this amendment does not suggest that it will take this away.
Right. And just to underscore, we have case law from the U.S. Supreme Court that is consistent with Maria's statement here.
Okay, great. Now, Dr. Jonathan, I want to just ask you, because we've got 5 minutes left and we've got a couple other things to cover. I think you wanted to talk about the reasons someone might vote yes and the reasons why someone might vote no. I think I might have interrupted you on that.
Oh, no. Okay, well, just briefly, I mean, it seems to me that abortion itself is a really difficult issue. And some people might say that either, I don't think we should allow abortion either at all or except in limited exceptional circumstances. And issue one would provide for a more expansive abortion right that I'm comfortable with. Now, whether you agree with that or not, I think you have to say that that's a reasonable argument that goes to the merits, as opposed to the gender-affirming care or the undercutting of parental rights. That's all I mean to say. And I think every individual voter needs to make an individual decision about how much, if at all, you are comfortable with having legal protection for abortion. And you should vote yes or no on that basis, and not on the basis of these kind of side issues.
Maria?
Yeah, that's a fair point. I agree with that. I mean, I think the heart of it is, do you want abortion to be something that, the patient and the doctor decide on, or do you think that there's a role for legislators to decide on abortion care? And that's really the heart of it. That's the decision to make. Is it something that an individual and their doctor decide, or is it something that we want the state to decide?
Thank you. And then that also, given in mind that it also encompasses these other things, right, Maria? So it's, again, let's go back to contraception, miscarriage care, continuing a pregnancy. It protects all of those things. And so is that a decision that the state should be, should this 6-week ban stand? Because I think functionally that's what we need to understand, right? Let's make it clear, if someone needs abortion care, if someone needs miscarriage care today, that is protected because of a legal stay. But what happens in November directly will impact the future of all of these decisions. And it could be that Ohio, if it fails, it reverts to the 6-week ban. or if it wins, then we protect all of these issues, right? Like access to all the various kinds of reproductive care. So one thing I wanted to mention to everyone is that vote411.org is our voter guide that was developed in partnership with some legal scholars and actually some newspaper editors to make sure we were being fair. If you go to vote411.org, you have to put in your address and then pull up your ballot, and you will see the language about what it does and does not do. We will be continuing to do other programs. Elizabeth shared 2 websites with us. And Elizabeth, would you just jump in and explain what those 2 websites are?
Sure. We've had some folks asking campaign questions, and I just want to reiterate that we are not part of any campaign one way or the other. The 2 links that I put in the chat are for the Ohioans United for Reproductive Rights, which is the Yes on Issue 1 campaign, and the other one is Protect Women Ohio, which is the No on Issue 1 campaign. So for people who want to reach out to them directly or want to learn more specifically from their websites, that is where to go. I also put an FAQ in the chat that does have who is supporting these organizations, and that might be helpful too.
Great, thank you. Final thoughts, Jonathan, and then Maria. And I'll just note that we got a couple questions about contraception at the end, which I think it's just that the stuff was so complicated, it's hard to follow all of it. But final thoughts, 1 minute, Jonathan, and then I'll give you a minute, Maria.
I'm not sure that I have a whole lot to say here. This is a very important issue, whichever side of the question you come down on, and I hope that people will cast informed votes that reflect the really hard parts of this proposition, and not get sidetracked on a lot of symbolic issues that really are beside the point.
Thank you.
Hard to summarize. I will say the contraception stuff is fascinating to me. So for those of you we didn't get to talk about it, I'd love to talk about it with you another time. I think contraception access is so important and really interesting. I guess my final thing would be, I think it's just important to vote, right? I think to the extent that we I think where we get in trouble is where the vote doesn't reflect the will of the people because people are not voting. So I guess my final message would just be, I hope that folks go out, and I hope that they vote.
All right, let's go ahead and bring up those slides. Elizabeth, when is the voter registration deadline? And while she is, I think she's
muted. The voter registration deadline is October 10th, and early voting starts the next day.
So make sure that you register to vote, you update your registration, and actually everyone checks their registration to make sure it's accurate by that date. Please consider being a member of the League. Next slide. Members and donors are the lifeblood of what we do here at League, and our volunteers across the state. So for example, we do have Issue 1 info cards that we are making free across the state. Donations go to things like that. And if you're interested in getting some of those materials, you can contact Elizabeth. We are on social media, so please join us. And do we have anything else? Thank you for joining us. I just want to say that the best thing we can do of service to voters is make sure they know that voter registration deadline, make sure they know the rules for accessing the ballot. You know, there's a complicated early vote schedule. There's now new ID laws. We are here to assist with that, as well as promote good information about Issue 1 on the November ballot. If your local league wants to do a program like this that demystifies what it means, we're here to help you. And if there's anything else that you need for educating voters, please feel free to contact us by email or phone. And with that, I just want to thank Jonathan and Maria for taking your time on a Saturday morning, as well as Munia and Michael behind the scenes, and Elizabeth for pulling all this together. So thank you. I hope you all have a wonderful weekend.
Thanks, everybody.